Okay, this is Great Lakes Home Health Services, Inc. Versus Van Duzen et al., docket number 20-154CB. This is the time set for hearing on the defendant's motion to compel. And I'll take appearances first for the record. Please, we can start with plaintiff.
Good morning, Your Honor, or good afternoon, I'm sorry. This is Ryan Bohannon on behalf of the plaintiff.
Good morning, Your Honor. Brendan Beer on behalf of the defendants.
Okay, and Mr. Beer, your motion, you can go ahead.
Thank you, Your Honor. I don't want to belabor the issue. Your Honor has read the compel and the exhibits, as well as Mr. Bohannon's response. As you, I think, already know, this case is one of several cases that Mr. Bohannon and I are handling for our respective clients across the state. We have had some discovery battles in a number of different courtrooms, and I'm going to try to take an active approach towards trying to come to a more congenial way to resolve these issues, because we seem to be stuck in the mud on a lot of items. Okay, and I sent out discovery requests, and they're attached to my motion as Exhibit A in December of last year. Okay, and if you take a look at those requests, and they're attached as Exhibit A, I had a series of interrogatories, 19 of them specific, that specifically asked questions directly related to paragraphs within the second amended complaint filed by the defendant, or filed by the plaintiffs. Apologize. I mean, every interrogatory just says something as simple as, listen, I'm going to just read one. Identify each and every breach or disruption of plaintiff's relationships and expectancies that were caused in any way by the actions or inactions of any agent or employee of any of the corporate defendants as alleged in paragraph 46 of the second amended complaint. So every one of these questions directly relate right back to the second amended complaint and says, hey, give me some information, identify some documents, respond directly to those allegations, and tell me what the basis for that allegation is. That's interrogatory 1 through 19. I also had document requests for productions, specifically 35 of them. And if the court takes the time to look at it, there is nothing vexatious in these requests. I mean, I've asked for simple things that are definitely relevant to the outcome of the proceeding, okay? And we worked pretty well with Mr. Bohannon throughout January and February with respect to these responses, because we have been through this as well. Responding to these takes a lot of time and a lot of effort, and you put your best foot forward to try to do it. And so Mr. Bohannon was telling us about how they had third-party vendors they were bringing in to help them do the searches, find relevant documents, and they, they, like us, were swamped with, this being a healthcare related industry, COVID related issues and things of that nature. And so we granted a number of extensions. And then at a certain point, Mr. Bohannon starts to tell us that, hey, my clients have some angst about providing some of this information, okay, and documentation. And that had existed in other cases where we had objected, and we even went in Oakland County to a discovery facilitator who worked with us to try to come up with a stipulated order of items that, would be produced as documentation in lieu of these, okay? And that's where these lists that you see attached are. And one of those such lists was entered in this court, okay, on October 22nd of 2020, okay? And in October of 2020. Then in November of 2020, we responded to that order, okay? And have since been in front of you on motions and allegations that we didn't respond fully and had to give additional responses, hundreds and even thousands of pages of additional responses. And my interrogatories and document requests, if you look at the order on October 22nd, they nearly mirror, okay, this order, because this order was issued a couple of months before I sent this discovery, okay, the order that you entered on the 22nd via stipulation. And I said, okay, this is the stuff I had to provide. This is the stuff I'd like to get. And most of what's in my requests are there. And so when Mr. Bohannon sent me, hey, here's a proposed list of stuff we think we want to provide, rather than responding to your document requests, two things were true. First off, while we agreed to alternative lists in your case and others, I've never not responded to interrogatories that Mr. Bohannon's office has submitted to my office. Never. Including the stipulated order that was entered in front of you on the 22nd. There were answers. One of the things I was required to do was answer some interrogatories that we had previously objected. So we have provided answers to Mr. Bohannon's office's interrogatories to us. At the very least, I'd like to get answers to interrogatories 1 through 19 so that I understand the basis of plaintiff's claims. As I never said that I didn't want answers to the interrogatories. The list that you see attached to my motion, and frankly, it's also attached to Mr. Bohannon's response, indeed, is a complete list of items with my strikes and my red lines based on a phone conference I had with him. And this was an attempt to come to some kind of solution about document protection, okay? And the big thing that's happening here is I've asked, and you can see it in the email, and it's specifically items 8 and 9. I've said, I want it to read that Alera will produce its admission and revenue data for any referral source identified, and in this case, this is the relevant one, by Van Duzen during her employment with Alera. So I asked them specifically, when she worked for you, who were the referral sources? Okay. And what was the amount of revenue and admission data that you had for those referral sources when she worked there? Okay. That mirrors exactly what I was told to produce, which is admission and revenue data for each source that Van Duzen contacted or solicited. And they got that, and you compelled this from all 3 entities, whether she worked there or not. And I didn't say that I was only going to give it to you based on if I thought she also solicited them when she worked for you. If the fight in this case is what it is, which is about whether Van Duzen had referral sources at Great Lakes when she worked there that she's calling on now, the type of business that those referral sources were doing with Great Lakes when she was there and what they're doing with us now. The amount of business is relevant because it goes to the defendant's damages or plaintiff's damages. If they were doing X amount of dollars of revenue before, and now they're doing 2X with those same referral sources, how are they damaged? And so to me, all of this stuff that I've asked for is completely relevant. And the exhibits, frankly, to my motion and Mr. Bohannon's motion show the literally months of conversation that we had to try to get responses to these interrogatories and document requests. And the fact that we're here clearly suggests, look, we couldn't come to any kind of consensus on how to limit the production. So what I would like is just, I'm not looking to get anyone sanctioned. I have no interest in that. I don't care. I understand attorneys, especially frankly today's day and age, because I'm up to here with Mr. Bohannon. Part of the problem I think we have with each other, because I know he's up to here with me, is I've never actually met the man in person. I mean, practicing law in this environment is difficult, and I'm trying my best to try to work through issues. I have no interest in anybody getting sanctioned. I just want to go back to the interrogatories that I sent in December. I want the court to take a look at them, and if you think anything I'm asking for is unreasonable or outside the scope of discovery, fine, but because I'm confident that it's not, and just order the plaintiffs to give me responses to the interrogatories and the document requests that I sent them 4 months ago so that I can get this case prepared, because my client's deposition is Friday and discovery's up in this case in June. It's been pending almost a year. Really just want to bring this case to a head so one way or another everybody understands how it's going to go. And so if you look at what I've asked for in A, there's not an interrogatory I asked that doesn't directly relate to one of the paragraphs within the second amended complaint. And if you look at the documents that I've asked for, I haven't asked for anything that's outside the scope of defendant Van Duzen, my client, what she did for the plaintiff, who she called on, what kind of revenue they generated from those sources. Here's the other thing though, when you see the list of referral sources that they give, I can tell you right now, my clients are telling me, I never told them who the referral source was when an admission would come in. They came up with that on their own, and I don't even know who half these people are. And frankly, or how they got on my list. I've never even spoken to them. And they say, and I know for a fact, some of these were people, other reps that Alera called on. So I've said, to the extent that same referral source is listed by a different Alera employee, I'd like to know that, because I think it's relevant, whether that referral source is my clients or just somebody 6 different people at Alera call on every day for one type of a business or another, because I think that's relevant. And so to me, I don't think I've asked for anything unreasonable in these requests. They have been pending for 4 months. I've never gotten any formal response or objection to them at all. I mean, at this point, I would just like the court to tell Mr. Bohannon to go back to the interrogatories and document requests that he sent out in December and respond to them the way that they should have by the end of January. And so we can move the case forward. Does the court have any questions of me specifically about what I've tried to keep the motion very simple, the request very simple. I've tried to tell the court what it is that I'm after. Is there anything?
No, I don't have any questions. I don't.
Thank you, Your Honor.
Mr. Bohannon?
Thank you, Your Honor. As Mr. Beers said, the way that we did discovery for our request to the defendants was to create a list that then ended up getting entered as a court order. We did the same thing when it came to their request to us, because things were duplicative, overbroad, and we said, let's just get a list. On March 2nd, I put that list together, and now I'm reading from it in the email. In lieu of serving written responses, answers, and objections to defendants' discovery requests, counsel made a few changes. He agreed to it in writing, as he admits in his brief. And so that's what we were going off of. That's why we haven't served answers to any interrogatories, because we had an agreement with him to not do that. Discovery is still open. He can reserve those interrogatories and we'll answer them. Then on April 2nd, I'm really quite not sure, and I'll be brief with this. I'm really quite not sure what he's trying to compel beyond that. April 2nd, we responded, the plaintiff did, we produced over 2,000 documents to the list. Some of the changes he made, the wording of them was slightly strange. So we did object just to say, this seems vague, but then I answered in writing and I said to him, nevertheless, for instance, he changed a request for referral source information to, quote, any referral source identified by Van Dusen during her employment with Alera. And so I said to him, after defendants review the data that we're producing, if they still insist on admission or revenue data from some other referral source, Alera will consider the request. On April 12th, they filed this motion. On April 20th, we had a phone call where I told him, tell me what it is you want, I'll give it to you. April 22nd, I followed up with an email that's attached as Exhibit I, and I said the same thing. I laid everything out and said, these require you to tell us some information. Whether it's search terms, whether it's a particular account executive that they want a report run for. And for each one of those, I said, identify the account executive that you want that list for, we'll give it to you. Identify a search term. We've got relativity and emails set up, ready to search. We'll run the searches. And then I just yesterday followed up on April 27th with a letter saying the same thing. They haven't once asked for a search term to be searched, an account executive for a report to be run. They haven't once asked us for a specific referral source they want revenue admission data from. And on that latter issue, on the revenue issue, I do just want to take a second. This is a non-compete, non-solicit case where Ms. Van Dusen was working for us as a sales rep. She left, went over to our competitor, and is doing the same job. What we have said that we would produce, so there's 3 possibilities as to what of our revenue is relevant in the case and goes to damages. There's referral sources she worked on at Alera and referral sources she's now working on at Caroline. Our revenue is definitely relevant on that point, and I have always said that we will give it to defendants. The other option is there's referral sources she worked on at Alera that she's not working on at Caroline. Well, that revenue is not relevant to anything. That doesn't matter. If she's not competing against us, that's not a breach of the contract. And then the third set of data could be information or referral sources she didn't have at Alera, but she does have at Caroline. That would be relevant to a breach of the non-compete. And I've said, no matter the account executive that comes from, we will give you that information. Of course, all of this requires the defendants to first produce their referral sources to us that she's been working on over at Caroline, and that came over about 1 hour ago. So I've already got it in my client's hands. My client's researching and is going to match that revenue data. And that's all that's relevant for damages. If Mr. Beer, after looking at that, still wants from some particular referral source for some reason our admission and revenue data, I'd be happy to consider it, look into it. If it's not overbroad, I don't think we mind producing it, but I don't know how that's relevant to the case. But bottom line is, I don't know what exactly it is he's trying to compel. We had an agreement in place, and I've offered him on 4 separate occasions now to, sit down, tell me the information that you want, that you have to identify per our agreement, and we'll produce it. And so I just don't think there's anything here to compel at all. That's all.
Okay, any rebuttal time, Mr. Beer?
Yes, briefly, Your Honor. First of all, I think what you can tell from looking at the emails is we did not have any agreement, okay? And when we reached this list in this case earlier with respect to the discovery requests that were sent by Mr. Bohannon's office, and we agreed upon the list of documents to be produced, we still answered interrogatories. And you can see from the stipulated order that you entered yourself on the 22nd, Mr. Bohannon not only expected, but demanded full and complete answers to those interrogatories, okay, and got them, regardless of the list which was entered with this court via a stipulated order. In this case, we never got a stipulated order entered at all with respect to limiting the production. And Mr. Bohannon says, oh, well, we got his red line of the list that I prepared, but we didn't think the way he redlined it was relevant. Well, then we don't have an agreement. I mean, go back to the interrogatories and the document requests I sent and give me answers to those, because there's nothing in there that's not responsive. This is an attempt. All I've asked them to do is identify the referral sources that Ms. Van Dusen supposedly had and called upon when she worked for the plaintiff. Then tell me the admission and revenue data for those referral sources so that I can see who she was calling on, what type of business you were getting from those people, and how much of it you were getting, to see whether any of that has changed since she's left. It's all completely relevant. And what they say is, well, here's the revenue for the sources we want to give you. Okay, you told us this is who she's calling on now. Here's where we think there's overlap, even though we're not going to give you anything to confirm that. And here's the revenue for those. All these other referral sources she called on, we're not giving you that. That's not relevant. They're the plaintiff in this case, and they have a burden to me, and I'm entitled to seek discovery about what it is they're claiming my client used to do and how that impacts what she can do today. I mean, I was ordered to give them hospice and revenue data for hospice patients for Caroline Health Group, Michigan, and Ms. Van Dusen doesn't even work there. She's not even employed by that entity, and it isn't even of common ownership with the entity she does work for. But I gave it to them because they came in here and I was ordered to give it, so they have it. Every patient we've ever had. And so this attempt to limit the scope of what I've asked for is not proper. If we don't have an agreement, if we can't reach a consensus, I'm entitled to ask interrogatories, which I did, all directly related to the complaint. I'm entitled to ask for document requests. Everyone I sent, frankly, was completely relevant and completely appropriate. And I'd like answers to those. And this idea that I should just resend them. What? I mean, I sent out 4 months ago, I sent these out. And
Thank you.
I have nothing more. Thank you, Your Honor.
Well, I spent a lot of time reading all of this, and, my polite word to describe this whole entire situation is it's a mess. I'm not reviewing the interrogatories that the defendant sent. And I have 2 reasons why I'm not reviewing the interrogatories that the defendant sent. The first is, and I'm not saying they're unreasonable or defendants aren't entitled or anything of that sort, but here's the reasons why. First of all, in the defendant's motion, in this motion to compel, the defendant says we had an agreement. We sent a first set of interrogatories, but we reached an agreement where we narrowed down the list. We had some communications back and forth, but we reached an agreed upon narrowed down list. And I don't know how the defendant could be any clearer in stating that as their position than they did in paragraphs 7, 8, 9, and 10 of their motion. And they even said in paragraph 10 that when the plaintiffs responded, they responded to the first set of interrogatories and requests for production as narrowed and agreed by the parties. So when I read that, it appeared evident to me that even though the defendants may have had every right in the world to have every single one of those interrogatories answered, and it may have been a reasonable request, there had been an agreement reached to narrow them and define them in a different way. That's fine. That's up to the lawyers and the parties. That's fine. But then very oddly, the defendant's motion in paragraph 17 says, since clearly no agreement between plaintiff and defendants relative to limiting the scope of plaintiff's responses was reached, then the defendants are asking the court to order the plaintiff to respond to their original first set of interrogatories and requests for production of documents. So those two positions seem very contradictory and very confusing to me. Clearly an agreement was reached and it has to be enforced. The agreement is in the defendant's Exhibit E. They attached it. They alleged it was the agreement. The plaintiff's answers are in the defendant's Exhibit F. So for me, going into this, the only question is whether Exhibit F and the supporting documents that went with it is responsive to the Exhibit E. There's a second reason, though, I'm not looking at the interrogatories, and that is the defendants say that the responses are non-responsive, but they don't particularly say how. The plaintiff seems to interpret the 4 categories that are listed in paragraph 16 of the defendant's motion as the ways in which they're deficient. But those 4 categories in paragraph 16 are only listed by the defendants to say that those are the areas that the information requested is relevant to. The defendants never tell me what is deficient. The defendants want answers to furthermore, the defendants want answers to their first set of interrogatories and requests for production after telling this court that there was an agreed upon narrowed list. So then to complicate matters further, there was an agreement on discovery as shown in Exhibit E, and the plaintiffs have even argued that in their response to this motion. So then it's really confounding that the plaintiffs responded to Exhibit E, in Exhibit E, to paragraphs 19, 20, and 21 by objecting that those requests were vague and irrelevant. And then plaintiffs have Exhibit I to their response to this motion that clarifies that they're willing to answer, but they need an opportunity to meet and confer with the defendant's counsel. So I hope that illustrates why I politely called this a mess. I'm denying the defendant's motion to compel because, again, there was an agreement. The defendants say there was an agreement. They haven't told me anything about what was deficient in particular. I think what makes more sense here is that I'm crossing my fingers and hopefully ordering counsel to meet and confer as needed on the agreed upon discovery. And if the plaintiff now wants to say, hey, going back to those original interrogatories, we're good with all that, fine, then do it. But I can't order anything with what I have here. And let me point out a couple things here. The only time you can file a motion to compel and say just order them to answer, period, is when there's been no response at all within the 28 days. But when answers have been provided and you feel that they're insufficient, then you have to specifically tell me which requests are in dispute. What was the answer that was provided? Because there's no doubt there's been discovery provided. And then how are the responses that were given or the answers that were given, how are those deficient? It's really not the judge's requirement to go through all the emails and figure out from the emails between the attorneys what you're saying is deficient. And even though I tried to do that in this case, it was impossible because it was a moving target all the time. So I would suggest too, or this is actually the third suggestion, that you not file any motion to compel either one of you unless you've met and conferred and tried to resolve the matter first. And then my final suggestion is that I hope that you will remember going forward, you're both members of a learned profession, and it's a profession that should command high respect from members of the community. And to the extent that it doesn't, it's when attorneys fall off the wagon in the areas of civility and professionalism. And I'm not calling either one of you out here individually, I'm calling you both out because I read the emails and the motions and briefs in this matter. And they're filled with snarkiness, gotchas, and name calling. And that's on both of your parts. And, you know, it's not an excuse that, oh, we can't meet face to face, because attorneys are held to the highest standards of civility and professionalism, regardless of whether they're speaking in person, whether they're speaking on the phone, whether they're on Zoom, or whether they're emailing each other. And frankly, I would be horrified if I were a practicing attorney and my emails and name calling and snarkiness were attached to a motion for the judge to read, because it's a poor reflection on both of you. So stop with the "you're a liar" and you know, all this other stuff that I read in the emails. And you know, when an attorney says in an email, you know, I got your email, it's really long, I'm on vacation, you don't tell the judge, well, he didn't answer because he went on vacation instead. You know, and again, if I've picked an example all on one side, I don't mean to do that. Those are the ones that are really sticking out in my head. Both sides are guilty. So start living up to the learned profession and the standards of our profession. And, you know, I personally have been licensed for 35 years. So I think that, you know, I know what of I speak. And I suggest that your first step should be to, at least if you can't meet in person or if you don't have access to Zoom, call each other up and talk on the phone and start with a commitment from both of you that you'll tone this way down and stop with this kind of behavior and try to work out some kind of a mutual agreement that everyone understands that will govern your discovery going forward. And if you can do that, and if there's still a problem, I don't hate discovery motions. Like all attorneys say, oh, I know you hate discovery motions. I don't. They're fine when attorneys handle themselves professionally and when the motions are clear in their requests for, you know, what's deficient and what do we still need. So I don't mind those at all. If you need my help, I'll be glad to hear a motion to compel. But I can't the way this is. And I'm denying the defendant's motion to compel.
Okay. Thank you, Your Honor. Thank you.
Well, sorry, it took me a minute to get off mute. Thank you, Your Honor.